Please, Your Honor. So may I pray for listing of a major appeal, my lord? Can be on Tuesday, my lord,
Give the list for what?
for others, my lord.
Give it
Service
to
has been completed, my lord. Tuesday. Wednesday,
court master will give the date.
my lord. Deeply obliged. Deeply obliged.
For referral to mediation. Item number 1. Yes, no, for admission. Item number 6.
Please, Your Lordship. This is a legal aid matter. The appellant is convicted under section 6 of the POCSO Act.
The appeal, the criminal appeal is directed. The criminal appeal under section 415. Bharatiya Nagarik Surakha Act 2023 is directed against a judgment and order dated 25/4/2025 passed by the Court of London, Special Judge, POCSO, Gulaghar, in special within bracket POCSO, because all these days this
Yes, yes.
I'll be rising early.
Yes.
Next week, Monday.
Wednesday.
Or Mr. B.D. Cornell Senior Counsel assisted by Miss S. Grain, Learned Counsel for the appellants, and Miss B. Vinaya, Senior Counsel in addition, Public Prosecutor for the opposite party, yes, respond number 1, state of some, so as of Mr. Cornell, Senior Counsel paying for the applicant's appellants has sought an accommodation, with the consent of the land, the additional public prosecutor has sought for and agreed to by the land council for the parties list the cases on
23rd.
We are blessed.
Number 9.
Tuesday.
Your objections, 5 minutes of record.
Yes,
So in this case,
Nine.
LCR arrived lordship. LCR received lordship, and they have filed their objections to lordship.
yes. Bill, meted. How do I was it? LCR received.
Lordship, LCR received
Paper book is to be prepared.
lordship.
Is it a case of 302? Okay.
302.
No necessity of respond number 2. Then what about this I?
I will file their objection with some record.
Lordship, may I clear lordship? Lordship, I am the lordship may take after lordship.
Preparation
day
of
after
paper
tomorrow.
book.
No lordship, day after tomorrow lordship. Because-
Not day after tomorrow. This will not go. It will go after 1 week.
lordship. In the meantime, lordship, I will prepare the compilations lordship and apply in.
Next week. Email appeal to you. Or Mr. I should. Land Council for the appellant and Miss A. Begum, sorry, B. and Senior Counsel in addition, public prosecutor for the respondent state. The records from the trial court. Yes, record from the trial courts have been received. Also, the office to prepare the paperwork, also please the case after 4 weeks for a report as regards readiness of the paper. I on Mr. I. U. Choudhury, counsel for the applicant appellant, and Ms. B. Bhuyan, and addition public procedure, and for the opposite party, just number one, respondent state of some. An objection on behalf of the state has been filed to the instant application under section 430, BNSS. Postal. As sought for by Mr. Choudhury, learned counsel for the applicants, appellants. Lays the case on a date in the next week.
Deep.
Yes,
This is an appeal from.
yes,
jail,
madam.
133 days.
And leave it to motion.
How much conviction?
20 years, Lordship. Under
20
section-
years. Will delay otherwise. She will be hard. Hard. Mr. B. Haldar, learned legal aid counsel
Yes, Lordship.
for the applicants. And appellant. And Miss B. Bhuyan, learned additional public prosecutor, learned senior counsel and additional public prosecutor. Assisted by Miss M. Das, R. Das, learned counsel for the opposite party, that's respondent state, respondent number one, state of Assam. The instant application under section 5 of the Limitation Act 1963 is preferred, seeking condemnation of delay of 133 days in filing the accompanying criminal appeal under section 415 within bracket 2 BNSS. Postal. The accompanying criminal appeal is preferred against a judgment, an order dated 30/08/2024, passed by the Court of Learned Special Judge within bracket POXO Themaji in special within bracket POXO case number 14 of 2024. Postal. By the judgment and order dated 30/2024, the applicant as the appellant, the applicant appellant has been convicted for the offense
Under section 4 of.
penetrative sexual assault under section 3, Protection of Children from Sexual Offences Act. And he has been sentenced under section 4 of the POXO Act to undergo rigorous imprisonment for 20 years and to pay a fine of rupees 10,000, in default of payment of fine, to undergo rigorous imprisonment for further 6 months. Postal. No. The applicant appellant has also been convicted under section 376. 1, Indian Penal Code. He has not been sentenced under the same section in view of section 42. POXO Act. Also. Para. We have gone through the statement and requirements application, more particularly, paragraph 5 thereof. Full stop. it is noticed that after the judgment and order of conviction and sentence dated 38/2024,
Yes, Lordship.
comma, the
38/2024.
the jail authorities had forwarded the petition for preferring an appeal to the District Legal Services Authority, Dhemaji, on 27/10/2024. Post of the this DSLA Dhemaji had thereafter forwarded the matter application of the applicant appellant to prepare an appeal to the Assam State Legal Services Authority, Guwahati, Assam, on 11/12/2024. Post of para. Having gone through the explanation provided in the application regarding the period of delay in filing the appeal, we are of the considered view that the applicant appellant has been able to explain the period of delay of 133 days, showing sufficient cause. Post of. Moreover, comma, as the applicant appellant has been sentenced to undergo rigorous imprisonment of 20 years, comma, the interest of justice will be better served if the appeal is heard on merits, leaving aside the technical aspects as regards the delay. Post of. Ms. Mia, Land Additional Public Prosecutor has submitted that since the period of sentence is 20 years, comma, the appeal can be heard on merits of the serving notice upon the respondent number 2 as informant, the opposite party number 2. Post of. We are of the view that service of notice upon the informant as opposite party can be dispensed with at this stage, as the matter of delay is an aspect which is to be considered by the court on the backdrop of sufficient cause. Post of. In any view of the matter, comma, the accompanying appeal is to be heard on merits only after ensuring service of notice.
Lordship, what's the number here?
No, the accompanying criminal appeal, comma, if admitted, comma, is to be heard only after ensuring service of notice upon the victim stroke informant stroke practice direction की ऐसे नाम तो practice direction practice direction. The informant should victim person. In view of the above discussion, by instance application.
Victim, guardian, support person, prevent.
in view of the above, the instant application seeking conversion delay of 133 days in filing the accompanying criminal appeal is allowed. The registry to register the criminal appeal and thereafter release the same for admission.
Mobilization.
Victim stroke guardian stroke support person.
Item number 11.
There is delay of 124 days in issuing the benefit application.
Hardness F Intas. Learned counsel for the applicant appellant. And Miss A Begum. At the 124 days. Judgment. Judgment and order dated
17/12.
17/12/2024. Court of Additional Session Judge within bracket FTC Rongia Kamro. Sessions case number 11 of 2023. E76 2N. Not in the practice direction. But I would case number to Kuluniki, session case number sons. By the judgment and order dated 17/12/2024, the applicant appellant has been convicted for the offense under section 376 within bracket 2 within bracket N small n, Indian Penal Code, and he has been sentenced to undergo a rigorous imprisonment for 13 years and to pay a fine of ₹5,000 with a default stipulation. Post up. The applicant appellant, oh sorry. Oh, no. We have gone through the statements and awareness made in the instant application, more particularly, Paragraph 3. বাকীখিনি লিখি দিব আৰু এইখিনি একে লিখি দিব। এই চাৰ্ভিচৰ নোটিছবোৰৰ কাৰণে, এই আগতে যে চাৰ্ভিচৰ নোটিছ এইখিনি লিখিব দৰকাৰ নাই। আপোনাৰ ৰেচপন্ড নাম্বাৰ 2 বা অপজিট পাৰ্টি নাম্বাৰ 2 নট ৰিকুৱাৰ্ড, সেইখিনি নালাগে ন, বাকীখিনি এইখিনি ডিলিট কৰি বাকীখিনি লিখি দিম।
For hearing. Items 12 and 13.
What are these matters?
No, I have prepared a list of eggs.
Appeal. Appeal is from which?
Getting out of the bracket.
No, I will do.
Bracket that the judgment delivered by the district judge. As part of the provision of the.
No, in the appeal, where is the judgment?
No, I have prepared.
Memo appeal, just a moment.
The hefty petition. So I simply segregated the
No, that
relevant.
is why first I have to understand.
Okay.
Where is the judgment otherwise?
Your lordship may go through my paper book, it will be convenient. Because I have.
In the, no, in the memo appeal, where is the judgment?
Actually, in fact, no, I have prepared paper book.
No, I am asking a question. In the memo appeal, where is the judgment?
Your lordship may kindly
Page,
bear,
page.
your lordship may kindly bear with me. I have prepared a book.
I have understood. I have understood. But please take me to the page where that judgment is annexed in the memo appeal.
That is a bit difficult to.
Page number, my lord, 20, 20, my lord. 2251. That is the judgment.
Page number?
20. Memo of it,
Appeal page 20.
20 to 51.
20.
20, ma'am. 20 to 51.
20.
Annexer,
This is a, get
they have annexed various documents in the house.
this is with regard to what?
They relate to compensation by
Compensation for
for land.
land acquisition. Land acquisition.
Land not acquired, therefore, the village people, they have filed a suit for damage.
Your lordship may
Yeah.
kindly go through my notes. It will be convenient for your lordship to understand.
LCR has been called for.
Huh? Notes addition.
When memo of appeal is before your lordship, the note will right now not help you. What are the grounds they have taken in the memo of appeal? That is important. And in the title.
Appeal is prepared by whom?
Preferred by.
By the railway, NFL railway.
NF Railway.
But my lord, here thing is that, my lord, appeal not prepared by the Union of India. Union of India represent by
No,
the general man.
Okay, we'll go into that aspect later on. First, let me understand the basic things.
Yes.
And what are these eyes? So many eyes.
However, my lord, one is consolidated objection, which it is a mistake.
1 minute. 4269. 4269. Let me just have a look first. There was delay in
Delay
preferring the appeal.
No, that has been condoned.
1 minute.
That was in
No, no,
complaint and
four-
against that condemnation
four-
order, they preferred an
1
SLP.
minute, 1 minute. 4269 was the application
For
for condonation of delay.
delay for-
Delay
Where is the order whereby this delay was condoned? Is condoned subject to payment of 1 lakh.
Yes, that possible.
1 lakh.
And they preferred an appeal before the Supreme Court against this order. Let me argue, if you argue.
1 minute, 1 minute.
And Supreme Court,
This
Send-
was 4/5/2019. Appeal was, then you deposited 1 lakh
Possible.
cost for condonation. Okay. Where is that Supreme Court?
Supreme Court.
Against that, the degree holders, they approved before the Supreme Court. And because of
1 minute. Four two six nine. Where is the Supreme Court order? Any idea?
Supreme Court not interfere in the matter, my lord.
Any
Only
copy of the order?
copy of the order.
Yes. 1 minute. When the appeal was admitted?
Appeal admitted.
No, no, when? Green. Eighteen eight. Minutes. Mr. Dasgupta, you got an interim order of status quo before condonation of delay,
Yes, yes. In 2007.
contrary to CPC. Contrary to CPC,
That time execution was pending by for the land.
but that is contrary to CPC.
No, ultimately,
yes.
ultimately,
In
there are-
any view of the matter, in any view of the matter, otherwise it is contrary to CPC. If I am not wrong.
no, subsequently, this court passed an
It was the
order.
First type of order.
Subsequently passed an order whereby we were directed to pay the deposit the 50% of this amount.
No,
And that
that-
we had deposited.
No, in 2018, you got an status quo order. Delay was condoned, I think, later on.
No, what happened, Milad? Actually, we prepared a writ application.
I'm not taking any,
I-
because I cannot take any contrary view now.
No, the lordship did not take any contrary view.
No, I cannot take. What's good or what? Just
Initially, a
just
writ application was prepared. And it was pointed out that no writ will lie, we
very
had to prepare an appeal.
It seems to be protracted litigation. Protracted litigation.
So it will be better if your lordship go through my list of dates, the notes and argument.
I'll go through, but let me apprise myself with the so many IAs also. Just to have at least
No, I have understood. Yes, no,
be patient for some time. You take your seat, let us go through it. Please take your seats. Let me have
no problem.
and understanding. Definitely. CRP is for what? CRP is for?
Second case, for execution.
Okay, okay.
They have already filed-
Execution.
Yes. There they have filed a petition for a stay of execution proceedings. And stay of other judgment by the money right, both under order 41 rule 5. During pendency of the said stay petition by law, they have filed a CRP. Civil division.
So, first question is. My first question is, because 4269 IA, this was for condonation of delay. Right? Delay was condoned subject to deposit of
1 lakh.
1 lakh. There the status quo order was passed. Then you deposited 1 lakh.
Yes. sir.
So this is to be closed. Why in the cause list?
That-
No, one should, otherwise so many IAs
but
without,
because no
which is
relevance-
going to serve no purpose.
No purpose.
It should be closed.
Yes. yes.
This 4269. So many IAs creates the confusion.
Yes, yes, yes. No IA is required. All the IA is required.
4269, this is IA for condonation of delay.
And-
That can be closed.
So,
1 minute. Then, what is the next 4027? 4027. 4089. So many IAs. 4089.
They have filed some.
So many IAs.
these are not required. Straight away you can go to the appeal.
No, but we should close. Why
Yes,
should
yes,
we?
yes. So, unnecessary.
Question is, disposal is of utmost importance. What is this? Application under order 6, rule 16. For striking out of defense pleading filed in the form of affidavit in opposition in IA 4269, 2017. Infractuous.
Infraction.
This is also infractuous. Huh?
Yes.
This is infractuous. So that is 4089. What is this 4027? 4027.
I think about 12, no?
4027 is the related to an objection. Objection. Status quo. It is also infraction.
That is also infractious.
All these are infractions.
409. Why?
Only appeal is allowed.
Order 39, Rule 4. Status quo order. That I think it has also infectious. Then what is more? C598. C598.
Infections, 50% we have clean.
You have
They
claimed.
Deposit they have.
No, we have also deposited this amount.
But primacy observation is made in this order, first order. Mr. Hazarika, that which cannot be resolved for upon hearing the so-and-so, this court finds that the matter involves multiple legal issues to be examined which cannot be revolved for the purpose of disbursing the security deposit made by the appellant in RFS so-and-so to the appellant without hearing the said appeal on merit.
Yes.
So privacy observation is made that without hearing the appeal, this order
Yeah.
cannot be made. So this
But-
is also become infractious.
And we have
Or
deposited
not
that.
disposed of, not disposed of, kept it,
Infections.
but ultimately observation is made. So all these 4 eyes are to be closed. Okay. Then what is next IS in item number 13? 2275?
Let us hear the item number 12 only. It will resolve the item number 13.
Okay.
Hmm.
No, that's just for the purpose we have to know. We'll close this first. Let us be clear.
Yes, sir.
The
We
four,
understand the issue.
my lord, IA 4269.
First, we'll dispose of 4269.
4269, my lord, they consolidated something. Delay is there. We have filed consolidated. Because, my lord, here we have mentioned, your lordship.
No, 4269, it is for continuation of delay.
That is not there. Consolidated means we have challenged the validity, legality of the memo of it. As well as we have also challenged equally at the same time, condonation of it.
No, 4269 is their application.
There,
There they sought condonation of delay.
against that, we have filed a consolidated document.
That delay has been condoned,
Delay condon. but-
subject to deposit of 1 lakh.
Yes. that
And
is-
they have deposited 1 lakh.
Yes,
Against that order, you went to Supreme Court. That was dismissed,
yes,
right?
yes.
So, and thereafter appeal has been admitted. Without condoning the delay, appeal could not have been admitted.
Yes,
So this is going to serve no purpose.
but the state consolidated objection, we raise one.
You can raise up here.
We raise one. Appeal not required by the union law.
But that can be a
State
ground.
consolidated objection, it
Ah.
is stated.
But this has been done with.
Yes.
That appeal is not maintainable on the ground that Union of India has not preferred the appeal. That can be raised in the appeal
Definitely.
itself.
In the minute,
Yes,
by oral application,
yes.
yes. That may be.
That I'll observe in while disposing of this, is it not?
No problem.
NFL represented the Union of India and they
One
preferred
minute,
an
one-
appeal and
I'll
that point has been raised.
confused. Heart. Mr. A. Dasgupta, Learned Senior Counsel, assisted by Mr. Dr. B. N. Gogoi, Learned Counsel for the applicant. Applicants. Any state of Assam? Good stuff. Mr. D. C. K. Hazarika, Learned Counsel. And Mr. C. K. Hazarika, Learned Counsel for the respondent number 22, opposite party number 2216. Full stop. None has appeared for the respondent number 1, state of Assam. today on call. Post op. The instant application under Section 5 of the Limitation Act 1963 was preferred by the applicants seeking condonation of delay of 1289 days in filing the connected heel appeal. Challenging.
It was registered as a first appeal. Subsequently, it has been registered as a heel.
Connected heel appeal.
Connected appeal.
In the meantime, it has been changed.
Yes.
Nomenclature has been changed.
Initially, my lord, they have filed.
Heel appeal stroke RFA. Okay?
Yeah, initially they have filed repeat. A repeat they have challenged the judgment and order of the London
No.
High Court passed in
At this time, this is RFA.
Then
while-
it is converted to heel appeal.
Connected heel appeal stroke regular first appeal. To assail an order dated 10/3/2013 passed by the Deputy Commissioner Dima Hasao District, Haflong, in title suit number 06 of 2005. Post of para. After service of notice upon the opposite parties and after hearing the learned counsel for the parties, the period of delay of 1289 days, which had occurred in preferring the connected heel appeal stroke regular first appeal, was condoned by an order dated 5/4/2019, subject to the condition that the applicants would deposit a sum of rupees 1 lakh in the registry of the court within a period of 4 weeks therefrom. Full stop. The court had observed that the causes shown were sufficient enough to condone the delay. Full stop. The court had further observed that to compensate the loss, the opposite parties were to be compensated with a direction to pay the amount of rupees, sum of rupees 1 lakh, which was to be deposited by the applicants. Full stop. Para. Thereafter, on 30/4/2019, the applicants through the chief law assistant, through the senior law officer, NF Railway, Maligaon, deposited a check, a demand draft of rupees, demand draft dated 25/4/2019, issued by the State Bank of India, Maligaon branch, while an office letter dated 30/4/2019. Did you receive it?
No.
You did not receive it. On protest or what?
No, my lord, party is not interested to receive
Okay.
that cost
Full stop.
right now. As a whole. they
Para.
receive.
It is submitted by the learned counsel for the parties that against the order condoning the delay, the opposite parties had preferred a special petition before the Honorable Supreme Court of India. Also, the said lead petition, criminal special petition, was however declined. The admission of the said special petition was however declined by the Honorable Supreme Court of India,
But, my lord,
resulting in finality of the order dated 5/4/2019, condoning the delay. Full stop. As the Mr. Mr. Hazarika, the counsel, appearing for the opposite parties, has submitted that apart from in the objection filed to the application, the opposite parties, apart from raising objection as regards the explanation for delay, have also raised an objection regarding maintainability of the connected hill appeal stroke regular fast appeal on the ground that the connected hill appeal stroke regular fast appeal has not been preferred on behalf of the Union of India. And on that ground, the appeal is liable to be dismissed. Is liable to is not to be entertained and is liable to be dismissed. Full stop. We are not
Yes.
in support of such contention, he has submitted that there are authorities to be relied on. Full stop. Be that as it may, the instant application is solely for the purpose of condonation of the period of delay of 1 to 89 days under Section 5 of the Limitation Act 1963. Full stop. The order dated 5/4/2019, whereby the period of delay has already been condoned, has attained finality on compliance of the condition regarding deposit of the sum of ₹1 lakh and after dismissal of the special leave petition preferred against the said order by the Honorable Supreme Court of India. In the above view of the matter, there is no fruitful purpose is going to be served, keeping the instant application pending, as the period of delay has already been condoned. Full stop. The instant, therefore, the instant application stands accordingly closed. Full stop. The plea is the plea raised on behalf of the opposite parties regarding maintainability of the connected hill appeal stroke regular fast appeal can be considered while hearing the connected hill appeal stroke regular file appeal. Itu agor di দিব তাৰপিছত এইটো দিব closed. একটু hold.
Yeah, my lord.
1 minute. Anything to be added here?
Yes.
So sorry, the learned counsel for the learned counsel for the opposite parties are is at liberty.
Supreme Court has prepared
Huh.
to raise the issue.
So show me the order. I have been asking for the order.
That order.
You are not showing me the order.
That order is there.
There, where? So many files. Bag full. Show me the order. That's all.
It's on record file.
Please.
Sir,
My paper book, your lordship will find.
Is it there?
Page
Okay.
79,
last paragraph,
page 79.
last paragraph.
Have-
Okay, leave Special petition.
Page
Uh,
79.
Special leave to appeal. Special leave to appeal. Petition for special leave to appeal. Where is our school? 14185-14186/2019. Within bracket, John Ham Johari, GB of Diduki, I and others versus Union of India and others.
Last paragraph, the petitioner are at liberty to raise all connection.
I'll quote this so that
He will recite it.
no doubt about it. the Honorable Supreme Court of India, after hearing the parties, and perusal of records, the Honorable, after perusal of relevant materials, the Honorable Supreme Court of India has passed the following order. Has passed, no, on 8/7/2019, dismissed the special petition, full stop, the relevant excerpts of the order dated 8/7/2019. Read as under. গোটেইটো সৰু বেছি ডাঙৰ নাই। As the petitioners in SLP number so and so, that is the opposite party's hearing, I have been granted the liberty to raise all the contentions in the connected Hill appeal stroke regular first appeal, the Mr. Hazarika has submitted that the contentions of the opposite parties as regards maintainability of the connected Hill appeal stroke regular first appeal is to be considered at the time of its hearing. First off, in view of the leave granted by the Honorable Supreme Court of India in its order dated 8/7/2019, the opposite parties hearing, that is, the respondents in the connected Hill appeal stroke regular first appeal are at liberty to raise all the contentions regarding the maintainability of its maintainability and other contentions on merits. Close. Okay, what about this 4089? Infractious. Lord. Mr. Dasu, can you come back after 5 minutes?
No, no problem.
Only here. Very good. Very good. Okay. 4089. 4089. 4089. 4089.
4270.
4089. Please.
47. Also recorded.
Heard Mr. G.C. A. Hazarika, Learned Counsel for the applicants, and Mr. A. Dasgupta, Learned Senior Counsel, assisted by Mr. Dr. B.N. Gugoi, Learned Counsel for the opposite parties. The instant application under Order 6, Rule 16 of the Code of Civil Procedure 1908 is preferred for striking out the defense pleading filed in the form of an affidavit in opposition by the opposite party number 16 in IAC number 4269/2017 in Hill appeal regular first appeal number 137/2017. Postal. Paper book for both. Paper book. Paper book. Paper book. Page 79 and paper book. Okay. the applicants had preferred a special leave to appeal C number 14185/14186/2019 in connection with an order dated 5/4/2019 passed in IS civil number 4269/2017, arising out of Hill appeal regular first appeal number 137 of 2017. Post of the SLP was disposed of by an order dated 8/7/2019 by the Honorable Supreme Court of India. Post of the relevant excerpts of the order dated 8/7/2019 read as under. Fully to page 79 or negative. Para. In view of the liberty granted to the applicants to raise all contentions in the Hill appeal regular first appeal number 137/2017, Mr. Hazarika Learned Counsel for the applicants has submitted that the instant application can be closed in view of the liberty so granted. Post of that the instant application is according in view of the liberty so granted by the Honorable Supreme Court of India by the order dated 8/7/2019, the instant application stands closed. So. Uh, 3598/2022. Heard Mr. D.C.K. Hazarika, Learned Counsel for the applicants, and Mr. A. Dasgupta, Learned Senior Counsel, assisted by Mr. Dr. B.N. Gugoi, Learned Counsel for the opposite parties. Post of the instant application under section 151 CPC has been preferred by the applicants, praying for withdrawal of the 50% of the decretal amount, which has already been deposited by the opposite parties as appellants in the connected Hill appeal regular first appeal number 137 of 2017. Post of para. While admitting the connected Hill appeal regular first appeal by order dated, which was the order? Admission. By order dated 18/8/2022, Who is the order for deposit of decretal amount?
In the separation date.
Which order? Which order?
So,
It like Katok. The connected Hill appeal regular first appeal was admitted on 18/8/2020.
Honorable Justice Arundev Chaudhary was a past use of the motion. While admitting the appeal,
Nothing is there.
but I need the Arundev Chaudhary.
Ah,
Arundev Chaudhary for this order.
show me the order. 18/8/2022. See the order first.
Therefore, they filed an application for withdrawal.
No, first there should be the order. Deposit. Oh, in the IA, not in the. Oh. Along with the Hill appeal regular first appeal, number 137 of 2017, comma, the appellants had preferred an interlocutory application under Order 41, Rule 5, read with Section 151 Code of Civil Procedure for staying the operation of the impugned order dated 10/12/2023, passed by the learned, 2013, 10/12/2013, passed by the learned Deputy Commissioner, Dima Hasab District, Haflong, in title suit number 06/2005. The interlocutor, comma, registered as IA civil number 4270/2017. The interlocutory application IA 4270, IA civil number 4270/2017 was disposed of with a direction to the appellants to deposit 50% of the total decretal amount was disposed of on 18/8/2020. With a direction to deposit 50% of the total decretal amount in the registry of the court within a period of 4 weeks therefrom. And the interlocutory application IA civil number 4270/2017 was disposed of. Suspending the operation of the impugned order dated 10/12/2023, subject to deposit of the said 50% of the decretal amount. Para. The court in its order dated 5/1/2023 had observed that the appeal involves multiple legal issues to be examined, which cannot be resolved for the purpose of disbursing the decretal amount made by the appellants to the applicant without hearing the said appeal on merits. Full stop. But we are in agreement with the above view observed in the order dated 5/1/2023. Full stop. Meaning thereby, comma, meaning thereby, comma, the prayer made in this interlocutory application to disburse, to disburse, to withdraw the amount, that is 50% of the decretal amount, can be passed only at the time of disposal of the Hill Appeal Stroke Regular First Appeal number 137/2017. Full stop. In such view of the matter, comma, the instant interlocutory application stands closed with the observation that any prayer for withdrawal will be decided along with at the time of disposal of the connected Hill Appeal Stroke Regular First Appeal number 137/2017. Full stop. What is the remaining one? 4027. What is this?
4708.
Status quo order.
Yes, the petition they have held under order 4125. Yes.
We close this.
Yes, yes.
Heard Mr. D.C. A. Hazarikal, Land Council for the applicants. And Mr. A. Dasgupta, Land Senior Counsel, Estate by Dr. B. N. Gogoi, Land Council for the opposite parties. Opposite party number 22, sorry. Opposite party number. Opposite parties. First of all, council board of parties have submitted that in view of the orders passed in SLP number so and so, comma, order dated, order dated 18/8/2022 passed in connected hill appeal stroke regular first appeal number 137 of 2022 and I civil number 4270/2017, comma, and issue raised in this petition is not to be adjudicated at this stage, as the issue is to be adjudicated at a time of disposal of the connected hill appeal stroke regular first appeal. Also, in view of such submissions made by the Land Council Board of Parties, the instant interlocutor application stands accordingly closed. Yep. Okay. So
12.
now
I
it
cannot
is
tell.
hill appeal.
Next item is, I think
Next item is CRP 112.
that is arising out of the execution process.
So basically the hill appeal is to be
Hard.
adjudicated, right? Now here is the impugn order.
No, your lordship, I have prepared this paper with me.
This is a title suit.
I have prepared paper to,
Uh-huh.
only I have segregated the relevant documents on this appeal.
Not a complete paper.
Says to prepare a paper.
Actually, for
Any
our,
evidence laid? Any?
No, my lord, nothing. It is not a paper book.
it is
There
for
are
our,
just some documents they have placed before the court. All those documents available in the LCR, my.
all these documents are available in the memo of appeal. For the convenience of this honorable court below, I have segregated those documents. And
No,
placed-
I am asking just one few questions. During this title suit, any evidence was laid by the parties?
Yes, yes.
We have.
You have laid evidence. Railways laid evidence?
Yes, yes.
Formally, they have not adduced any.
Okay. Any witnesses were examined?
Court has examined
Okay.
our witnesses.
Your witnesses?
Yes.
Yeah. Are they part of this record? How many witnesses?
There are 14 witnesses.
Then, sir, we have to prepare the paper book. Otherwise, it will be very bulky. Otherwise, all these issues are not required. Other issues. Title suit.
Initially, we have filed PI before the High Court. And High Court has framed 3 or 4 issues.
Those were
Issues is to be determined by the learned
Okay.
tribunal below.
okay.
Now, court has framed all these issues by the learned tribunal. And this judgment has been delivered after determining the all issues framed by the learned tribunal.
Okay. Just let me have a look.
No, I have prepared a note, Lord. Well, if you go through the note, you'll be clear.
When there is
No,
ground-
if there are evidence, at least we have to,
Prepare a paper book. Yeah, do what your lordship will.
right? If there are evidence, otherwise it will be very difficult,
Yes, that is correct.
as my esteemed sister has pointed out. That will take care of the CRP also.
CRP.
CRP also related to the
Same issue.
step.
No paperwork
If
required.
the
for
hill appeal is allowed or hill appeal is dismissed,
CRP will be infractious.
it will become infractious.
Yes.
I think we have better have a paper book.
Yes.
Paper book means, my lord, there.
He'll appeal number 2.
Better, we have many, because long, my lord. English is the only
No.
judicial.
For
language.
our
Yes. Because.
perusal, instead of going into this,
Yes.
the judgment and the relevant evidence are to be contained in the paper book, that's all. If you have laid evidence, at least those documents should be part of the paper book.
They have declined cross.
Anyway,
Okay, good enough.
They have filed a petition before the learned court only to
Okay.
deliver the judge,
Okay,
and they have declined cross.
okay, let me start dictating that the registry should prepare the paper book. You just tell me who have laid evidence. You have laid evidence of 14 witnesses.
So prior to that, my lord, they have produced some land documents with revenue receipt. That is. the-
So means oral evidence plus documentary evidence. Okay, that should be part of the record.
no,
It will facilitate both of you and as well as us.
There are 106 land documents,
Okay, good.
patta documents, my.
all the
And-
relevant documents are in the big.
And my
Yes, sir.
lord,
Ah.
more than 100 land payment, revenue payment received. Even
So you have
there are.
exhibited documentary evidence.
Yes,
documented.
That's all.
we have also placed the document here.
Okay.
But the procedure laid down in the
That will,
CPC.
that will be, that will
for
be the burden of
exhibiting
this
the
court.
document, that letter of the CPC not followed in the.
That,
Later is not spirit, I think.
Letter of CPC is not applicable on the spirit of the. CPC.
Spirit is to be followed,
Yes,
not in letter.
later.
Okay.
Suppose.
Before the deputy
village man-
commissioner.
if a village man will go to the deputy commissioner and submit a document. Deputy commissioner, as per the provision of the special student, my lord, the documents
I could be-
accepted. Administration of Justice Act.
And
It's made,
Mr. Dasgupta and Mr. Hazarika, what are the statutes which are to be looked into? Please tell us.
no statute is required to be looked into.
I think
Only
it-
one thing, only one.
No,
thing
no,
what-
because it is at
Actually,
that
they are-
time, in 2013, judiciary was not separated.
not separate.
This is a very important aspect.
Yes.
Separate,
Right, it was only in 2017.
July,
That I know. So, at that time, there is a set of rules,
local.
local rules, where I think the spirit is to be followed, the principles of natural justice.
Yes. That is
And
why-
affording opportunity of being heard.
That is why it is registered as a hidden appeal. Yeah, sir.
Because stricto sensu, CPC is not.
Applicable.
Applicable.
Any established precedent regarding what kind of?
So I think my lord is the first legal appeal before some arguments.
So,
So
you have
it
to,
will be difficult to bring
Ah.
a case law in correction of such type.
There is a case law.
Particularly my lord is civil matter.
I can pass this act now.
this deputy commissioner is district council court.
Yes. Regional court, my lord. There are two courts, my lord. One is council court, another is a regional court. Regional court proceedings conducted by the deputy commissioner. And if any dispute arises.
No,
Both
Mr.
the-
Hazarika,
if both parties tribal, then
No.
letter will go to
No,
the
no,
council.
Mr. Hazarika. Sixth schedule area,
Yes, into the-
Assam,
yes,
para 20,
yes,
sixth schedule.
yes.
In Assam district, Dima Hasa Council and Karbi Anglong Autonomous Council.
In 2009, Karbi Anglong, it
Ah,
was abolished.
there is no regional council.
Yes, yes. Paragraph 4.
Regional court.
So if there is no regional council, there cannot be any regional court,
Yes, only district council code.
only district council.
District court.
Paragraph 4.
Because there are two, in the Guwahati High Court rules, there are two sets of rules. The Assam High Court jurisdiction over District Council Courts Order 1954
54.
Yes,
and Assam High Court jurisdiction over Regional Council Courts Order 1959.
yes.
In the absence of regional council, there cannot be regional council court. Only district council.
Only.
If district council court is presided over by the district commissioner, okay.
Yes.
Because we have to know
The
that
act says, Michael, regarding that.
No,
Deputy Commissioner. will-
somewhere it is there that spirit of CPC is to be followed.
In the rule, Michael, it is mentioned.
Which rule? Which rule?
Local action rule. The rule, my lord. Local action rule. I have come with a picture.
Paragraph 4 of 6 schedule.
Paragraph 4 of
6 schedule.
Constitution of India.
4 and 3. They will frame their own rules.
There is a certain.
District Council code. North Kasaril Autonomous Council District Administration of Justice Rules, 1955, my lord,
Issue the sum.
court edition. Legal action rules, court edition. The rules
This
of-
one,
Not this one, my lord.
this one,
The rules
1919?
1940
19,
1955.
54.
Dima Hasao,
1955, rule 39.
Dima Hasao. To Karbi Anglong. To Karbi Anglong. এটা কার্বি আংলং।
Connection in
This is Karbi Anglong. These two books are for Karbi Anglong.
Yes. Yeah, Dimasa is a hill district. Rule 39, it mentioned in rule 39. Guided by the spirit. Not to be bound by the letter of.
Let
the
us have a look. Forty-seven. Okay, spirit, 49.
Administration of
Okay,
justice.
it will-
not
it will-
after it rules.
Ah.
The old
Okay.
one. So not to
Okay,
go with the old one,
Now I got
then the rule is 41.
47, 49,
Yes, 40, yes.
village code, subordinate district council code, district council. Okay. Let us have a rule in the file, otherwise it will be difficult. Just a minute, I'll. Uh, heard Mr. A.
Old book is also,
Dasgupta.
old deputy also speaks same thing.
This is the rule, the North Council
Yes,
Hills
yes,
Autonomous District Administration of Justice Rules 1955.
yes.
Okay, I'll keep this in so that you can address. It's said by Learned Senior Counsel is A. Dasgupta, Learned Senior Counsel is said by Dr. B. N. Gugoi, Learned Counsel for the Appellants, and Mr. D. C. K. Hazarika, Learned Counsel for the
So respondent. Respondent number 2 to 16 probably.
respondent. Where is the memo of appeal? Ah.
Two-
Respondent number
16.
2 to 16.
2 to 16.
So Samnan has appeared for the respondent number 1, State of Assam today on call. Post of. The instant appeal is preferred against an order dated 10/12/2013 passed by the Additional Deputy Commissioner Roman N, Deputy Commissioner in charge, Dima Hasao District, Haplong, in title suit number 6 of 2005. Post of. By the order dated 10/12/2013, the claim application preferred by the respondent number 2 to 16 was allowed, and the respondents NF Railway authorities to the general manager was directed to make payment of a sum of rupees 34,66,81,397.
297 no?
397. To the affected person within a period of 30 days from the date of the order, failing which, the respondents would have to bear an interest at 6% per annum from the date of filing of the claim application till 10/12/2013 and 9% interest per annum. Interest at 9% per annum from the date of from 10/12/2013 till the date of actual payment. Full stop. Para. The appeal has already been admitted for hearing. Full stop. It is submitted by Mr. Hazarika, Learned Counsel, for the respondent number 2 to 16 that in the course of the proceedings of title suit number 6 of 2005, comma, the claimants had adduced oral evidence to a number of witnesses, 14 number of witnesses.
Evidence of, yeah, public.
And exhibited a number of documentary evidence. Railway,
Railway Authority also exhibited number of documents.
it is submitted by Mr. Dasgupta, the learned senior counsel appearing for the appellants, that documentary evidence were also adduced
By the Railway Authority.
by the respondent railway authorities. Full stop. Where we are of the considered view that for the purpose of adjudicating the appeal, comma, the document, oral evidence and the documentary evidence laid during the proceedings of title suit.
Recording. Yes, but this record.
Sorry, and the
Evidence.
oral evidence, oral evidence in the form of affidavit are required to be, would fall for consideration and appreciation. So in such view of the matter, comma, a paper book containing the evidence so adduced, including the order impugned, is found essential. First of, as the TCR has already been received,
But there are some orders of this honorable court from read petition and read appeal.
okay, I'll give the liberty to prepare that. You have already prepared?
Yes, yes, in the list of dates. No, I have
No,
given.
if any, we are confining the paper book
Hmm.
to the impugned order and the evidence laid during the trial.
That about some other high court
That
order.
others you prepare.
And
Yes, I have
Registry will
prepared.
file.
No, I have already prepared.
order passed by the learned court below time to time since to.
Order seats, order seats,
No, all orders of the learned trial.
order seats,
Yes.
Order seats?
Order seats, Seats
No, I have
and the
prepared.
order seats
Yes.
of the registry shall prepare the paper book. We shall include the evidence, dash, evidence, comma, oral in the form of affidavits and documentary evidence, comma, the impugned order, and the order seats, including the order dated 10/12/2023 of title suit number 6 of 2005.
And defined orders passed by this honorable court.
2313. 12,
13,
yes.
13. Full stop.
And
So other litigation, Mr. Dasgupta,
yes,
if any other PIL
Yes,
repetition,
yes.
you prepare, otherwise registry will file difficult.
no, I have already prepared.
You have already prepared and you press it.
So
Right.
that liberty. is allowed.
Para,
Time to time, they have filed some petition in the trial court. That is should be done in the paper book. Because sometimes they have filed for adjournment, sometimes they have filed, they could not.
adjournment we are not,
These are not
adjournment is nothing.
They could not test out the court has.
You
given-
point out, first we have to Go to the merit,
Petitions are important.
merits.
They have submitted petition and saying that we have no evidence to educe in the trial court to prove our ownership of the land. That petition is also come with the paper book, my lord, because they have.
No. Ultimately,
They have.
all the
We'll
papers
go
will be.
through, if required, this will be here.
Yeah, this will
You
be here.
point
there.
out. Otherwise, registry people are not that
Yeah,
expert.
Engineer.
Go through all papers.
No, he need not.
Only
Paper book is
documented
there.
and oral evidence in the form of affidavit, order sheets, and finally the impugn order.
Hmm.
And whatever you want to rely on, LCR TCR will be available. So you point out, if required, we'll take out an extract.
And
And
different
other orders passed in different
Passed.
writ petitions or PILs,
and
you
it
place
appeal.
it in a spiral binding.
Yes, I have
You
already,
already prepared.
I have already prepared and I can
Ah.
class it up.
The learned counsel for the parties would be at liberty to place any relevant materials at the time of hearing. Full stop. The learned counsel for the parties have further submitted that the title suit number no, at the 6th of 2005. Sorry, not again. The relevant statute, the provisions of the somebody has submitted that the statute applicable is the North Kasar Hills Autonomous Districts within bracket Administration of Justice bracket close rules, 1955. Right. And volume 1, page 283 pora 299, huh? It was Xerox query, pilot might be.
And page number 98, 99.
Huh?
Page number 98 and 99.
98 of this book.
Same book.
Oh,
Page number 98 and 99.
okay.
That is the act.
Okay.
And
Are you likibo?
98 and 99 act.
Okay. Edukon. Comma
Jurisdiction,
the
regarding
it rules also the Assam Autonomous Districts Administration of Justice Act 1960. The Assam Autonomous Districts Administration of Justice within bracket miscellaneous provisions bracket close Act 1957.
Power of power of
The statutes and the rules applicable are so that it is in the file, otherwise it will take consume time. Lays the case appeal along with উপর CRP to লিখিব দেই appeal আৰু CRP to লিখিব বুঝছে তাৰ মানে কোনটো থাকে জানে এই 12 IA বোৰ বাদ এটো সেপাৰেট অৰ্ডাৰ পাস কৰা হৈ গৈছে 12 all IAs are বাদ 12 তাৰপিছত লগত CRP 13 টো যিটো তাৰ লগত CRP IA টো তাৰমানে টোটাল 3টা থাকিব হিল এপিলটো থাকিব CRP টো থাকিব আৰু CRP I টো থাকিব ঠিক আছে বাকি কিটা ডিফাৰেন্ট অৰ্ডাৰ পাস কৰি ডিসপোজ কৰা হৈ গৈছে Before Independence Day or after Independence Day?
Subject to lordship.
For a report or no, we are expediting the matter.
Yes, sir. Any day.
30, okay, exactly on 13th of August for a report as regards readiness of the paper book. If it is ready, you check everything is okay. Okay, otherwise you supplement. Definitely, if it is ready, it will be provided. 13th of August. Book আপনি note করে রাখিব। There is an amendment also.
No, there's a new act. Separation of judiciary.
এখনো রাখি দেবো, এখনো লিখি দিব তাতে। এখনো লিখি দিব। Miss Dr. Gogoi, whatever I have stated, these 3 acts and the rules, you prepare a compilation in a form of spiral binding. In addition to the paper book will be prepared by registry. These 3 acts, whatever amendments are also there, you prepare a compilation so that it is placed instead of going through all these files.
That will be better.
I think that will be concise.
Hmm.
Have you understood?
Wait,
3 acts amendment including plus the rules 1955 which has been referred to by Hajarika. Or either of you, but make one compilation. Because hill appeals are not often coming.
This is new to us.
Should I keep it now or on that date?
Wait.
You place it on the next date. We'll examine thereafter. Yes, fine.
No, I gave them this real copy.
No, you keep it on 13th August, you place it. Because all these other IAs will be gone. Yes, will be,
Really precise.
yes, precise. Yes. This will keep.
Keep.
Pilot main heritage tool.
The code edition, got to be kept by the code, my lord.
Which one?
Our book that.
No.
No.
They will make it.
We'll be returning you. That's it. Yes, 14.
And since my lord, considering the health condition of the present appellant, my lord, this honorable court on 25 to 25, without considering our I, my lord, fixed for hearing matter. So, my lord, in the meantime, my lord, the private respondents, my lord, preferred, in this matter, total 8 accused, my lord, 7 acquitted and 1 is conviction. I am before this court against conviction, my lord.
You are the only one who has been convicted.
Convicted.
And
rest were acquitted, my lord.
Huh.
Again, acquittal, my lord.
How many accused who stood the trial?
Matter 8.
8.
I must clear one thing. In FIRs, 8 accused were there. One was.
How many faced the trial?
7 faced the trial.
7 faced the trial.
6 were acquitted. 1 was convicted. Against conviction, they are here. Against acquittal, I have filed an appeal, being the informant in this of the FIR. And here, a limitation petition was there. So if my prayer today would be if this limitation is considered and my appeal is still now it is serial number. If it is numbered, both the things can be heard together.
Okay. Paperwork is ready.
Yes,
Paperwork
maybe
is ready.
my
Good enough. That will
It will cover both the case.
that will cover.
Yes.
Which one is the IA?
IA is 111 of 2025.
And who is for the Mr. Deka? You are there.
I'm for the Fajr, my lord.
Yes.
Yes.
Any objection?
I don't have any objection, but my hearing is within not done.
Anyway, these are two same
Yes.
thing. If the same paperwork will serve the purpose,
Same paper.
no point keeping it.
Yes, my lord.
Okay, we'll condone the delay. You have any objection? Huh? In the IA?
Lordship may condone, my lord.
IA 97 or 111.
Actually, there is a mistake in the causeless. They have tagged this IA along with their appeal.
Okay.
Our appeal
What is your serial number? Okay, serial number.
Yes,
Heard.
serial number.
Your name, please.
MK Chaudhary. Arjun K. Chaudhary.
MK Chaudhary. Learned counsel for the applicant. 111, huh? Ms. Begum, you have any objection? A Begum, Miss A Begum, learned counsel for the opposite party number 1, State of Assam. And Mr. P. K. Deka, learned counsel for the opposite party number 227. Question. The instant application under Section 5 of the Limitation Act 1963 is preferred, seeking condonation of delay of 201 days in preferring the connected criminal appeal.
This serial number is 10451.
My lord, I'm sorry, my lord. In the opposite party, I'm representing 2, 3, 5 only, and 5 intermittent died, my lord.
Oh, 1 minute. 2,
3 and 5
2, 3,
and
and
5
5.
only.
PK Deka.
6 and 6.
Mr. M. Khan, learned counsel for the opposite party number 4, 6, and 7. Postal. 201 days in preferring the connected criminal appeal.
Serial,
90. Serial number to 90.
serial number is 10451.
ওই তো নাম্বার উপর ফাইলের উপর নাম্বার লিখেছি উইথ ফাইলিং নাম্বার criminal appeal 10451/2024 dated 12/11/2020. Post up. Para. The applicant herein as the appellant has preferred the said criminal appeal filing number against a judgment under the
Under 413.
under section 413. It is equivalent to 372.
Yes.
Okay. 413, Bharatiya Nagorik Puraka Onita 2023 against the judgment and order dated
Dated 22/12/2023.
22/12/2023 passed by the Court of Learned Sessions Judge Sunitpur Tejpur within bracket the trial court for spot in Sessions case number 105/2012. Post up. In the trial of Sessions case number 105/2012 from 7 such accused persons face the trial for various offenses, including the offense under section 302 IPC. Post up. By the learned trial court. After conclusion of trial, has found one such-seated accused, namely Muhammad Fazar Ali,
My lord.
guilty of the offense under section 302 IPC. Full stop. Holding that the charges against the other 6 such-seated accused persons not guilty of the offenses, thus other 6 such-seated accused persons were acquitted from the charges. Full stop. Being aggrieved by and dissatisfied with the order of acquittal of the said six seated accused persons. That is, comma, the opposite party number 227 hearing. The accompanying criminal appeal has been preferred. Post of para. We have gone through the statement and environments made in the instant interlocutory application, including a more particular comma paragraph
Lordship, paragraph 5, page number 4.
5 thereof. Full stop. Para. Learned Mr. Dekar, learned counsel for the opposite party number so and so, and Mr. Khan, learned opposite counsel for the opposite party number so and so, have submitted that they have no objection if the period of delay is condoned and the appeal is hard on merits. So Mr. Khan has further submitted that opposite party number 4. You are saying, he is not saying.
Well, I'm for 235.
4 you are saying he died.
The 5 died, my lord.
Okay. Mr. Dekar, learned counsel for the learned counsel has submitted that
Muhammad Jamaluddin, my lord.
opposite party number 5, namely
As per the information received from the my client.
Jamaluddin,
Yes,
Muhammad Jamal, has expired after the judgment dated 22/12/2023 passed by the learned trial court. And the connected criminal appeal, comma, even if it is admitted, comma, would stand abated insofar as the opposite party number 5 is concerned. We'll make observation
Yes, my
there.
lord. Yes, my lord.
Ms. A. Begum, learned additional public prosecutor, has also fairly submitted that the state has no objection if the period of delay is condoned and the appeal is hard on merits. So in view of the same, in view of the above, comma, having regard to the statements and environments made in the application, comma, we have the considered view that the applicant has been able to explain the period of delay of 201 days, showing sufficient cause. Post op. The instant interlocutory application is accordingly allowed. Post op. The learned counsel for the registry to the Taragod. The learned counsel for the parties have further submitted that another criminal appeal, comma, criminal appeal number 30/2024,
My lord.
has arisen out of the same judgment dated so and so. And the paper book
Ready.
has already been prepared. Post of after condonation, they have further submitted that after condonation of delay, comma, the accompanying criminal appeal can be heard. Accompanying criminal appeal, comma, after registration, comma, can be heard with criminal appeal number 30/2024 together. Post of allowed করে দিব the registry. Last one. To register the accompanying criminal appeal with filing number so and so, and to release the appeal for admission on a date in the next week.
Give your blessing.
The name of okay. The name of the councils who have entered appearance for the respond number, opposite party does respond number 2 to 7 are to be reflected in the cause list. That will do,
Yes, my lord.
but you check the cause list also
Yes.
next week.
Deeply obliged, my lord.